Assalamu alaikum. I'm Gina Samuel-Richards, Solicitor Director at AGR Law, and you're listening to Radio Ramadan on DAB and FM 87.7, and this is The Law Show. If you want to ring in with your questions, we're on WhatsApp 0774885555 or the studio line on Leicester 4822086, and you can get us on social media, Facebook, YouTube, LinkedIn, TikTok, Twitter, Spotify, Instagram, and wherever else you actually get your social media from. Today we're looking at family law, and in the studio with me I have Harpreet Sanghera. Harpreet is of the recently incorporated HS Legal. She's a passionate family solicitor specialising in domestic abuse and matters, complex matters in divorce and finances. And I've also on screen got Sushma Kotecha. Sushma is a qualified solicitor, but she spent significant parts of her life practicing family law. She's left practice in 2021 to set up and focus on mediation and coaching. And Sushma now runs a holistic family mediation coaching. Welcome, ladies.
Hi.
Hey.
I was wondering if you both want to tell us a little bit more about what you do and what it means, and then we can get into the really difficult questions. So do you want to go first, Harpreet, as you're in the studio?
Yeah, sure. So I'm Harpreet Sanghera. I'm a family law solicitor, as Gina's just said. I specialise in divorce, children, financial matters and domestic abuse matters where clients need that assistance. I've been qualified for over 10 years now and been doing it a lot longer than that. So I do have quite a bit of experience in attending court and advising clients generally on those issues.
Okay, thank you. And Sushma?
Hey, so I guess my background is very similar to both of yours. Was a practicing solicitor for 27 years. Gave that up over lockdown, as you said, Gina, to set up the holistic online family mediation and coaching service. So I qualified as a mediator back in 2010. And then I undertook a diploma in holistic life coaching and mind-body practitioner after I gave up law to, I guess, enhance my skill set and to provide a alternative to court proceedings and litigation. So I guess it's like we can work collaboratively together, and we'll have all different avenues covered in today's session.
That's great.
With the out of court as well as the court way.
Indeed. And as we're talking about out of court things, so Sushma, what is non-court dispute resolution?
Yeah, so it says what it says on the tin, meaning any options that are going to assist those that are listening to this show on how to resolve issues relating to their family breakup outside the courtroom. There are various options, one of which is mediation, which is, I'd say, the most significant non-court dispute resolution option, but there are a host of others. The other main ones are early neutral evaluation, arbitration. There are roundtable meetings, collaborative law. So we as practitioners within the family field are able to co-create and help our clients where it's safe and suitable, and I'd say probably 70% of cases, to try and resolve their disputes outside the courtroom. So that's what non-court dispute resolution is. And there is a spotlight at the moment because of the new changes that came into effect that enhanced, I guess, the role of magistrates and judges to ensure that if there are cases that go before the court, they are making sure that at all times throughout the process that we're trying to keep an eye on, can we help the parties resolve this outside the court? So I think there should be a shift in how lawyers are now functioning.
Okay, so if the judges are suggesting that things should be done outside of the court, how does the client or any of the parties access those sort of services?
Yeah, so if anybody's interested in actually exploring and finding out more about non-court dispute resolution, the first port of call is to arrange an initial meeting. It's known, the acronym is the MIAM, Mediation Information Assessment Meeting. So that's a standalone appointment, one-to-one confidential session with an accredited family mediator who'd be able to give the participant information on all the non-court dispute resolution options. So it's not just focusing on mediation. And we're also looking at other tools and resources that are going to help the parties that are going through divorce and separation. Quite often at those initial assessment meetings, we're signposting to counselling and therapy. You know, people are not ready to make decisions because their brain's been hijacked with the emotion and the trauma of divorce and separation. So our job initially is to do not only understand what their situation is and what issues they want to resolve, so finding out about what their needs are, they get a safe space to be heard and understood, but we're given all the different options that divorcing and separating couples have to try and help them reach a resolution. Now, sometimes non-court isn't going to be the way forward. So if it's extenuating circumstances, it's going to be down the court route. But the main thing is that they'll at least have all the information to make an informed decision as to which way they want to go forward. And quite often it is taking a breather, digesting the information, reflecting, and then deciding a way forward for them. So part of that assessment meeting is also carrying out safeguarding and screening. And that's where we are then, if there are any major concerns, typically severe domestic abuse, safeguarding issues, they are going to be those decisions that need to be undertaken through a court system.
Okay. And when choosing someone to help you as a mediator, for example, does it help to have someone that's had a family law background? Because there are many mediators out there that have never practiced family law.
Yeah, I guess it depends on the circumstances. So if you've got a situation where the participants are only looking not necessarily to deal with the financial side of the divorce and separation, but just focusing on children elements, some people may prefer to go to a mediator who has a therapeutic background. So you do get mediators who are from, counselling, therapeutic backgrounds. But you're absolutely right, where it's in all issues, family mediation, and the parties are looking to try and resolve finances, the divorce, fallout from the divorce and the children. They may prefer somebody like myself who's got a legal background, but, need to make it very clear that there are boundaries in place. I'm no longer a divorce lawyer. I don't give legal advice. I give tools, knowledge, resources, and information. And I'm always saying to participants, it's really important to take advice from people like yourselves, legal advice, financial advice, tax planning advice, whatever, to come in then and to make decisions that are going to be best informed.
Right. So if our listeners were going through divorce, they could use a mediator and their solicitors at the same time to get the best sort of holistic package.
Yeah, it's a collaborative process. That's really important to understand, because you're right. Quite often people think it's one or the other, but it's very dynamic and it's fluid, and it's not. And you don't. I always say to participants that yes, you might have to go down the court route because you've got parties got their head in the sand and they're not cooperating with disclosure, for example. But quite often you can have a litigated case, have your lawyers on board helping you with that. But I'm sure that you both will be aware that from time to time the court will, certainly since the rule changes come into place, might be encouraging those that haven't even thought about non-court dispute resolution to work alongside another forum, whether it's mediation, whether it's through early neutral evaluation or other ways forward. So yeah, absolutely, it's about we're all working together collaboratively.
Yeah, absolutely. And I suppose Harpreet, it also helps parties to get through the system much quicker, because if they're relying just on the court process alone, it takes quite some time, doesn't it?
Yes, and often the cases can be filtered out at mediation stage with an agreement coming into place thereafter. A lot of clients, in my experience, can be quite reluctant, however, to try mediation initially, because it's not something they've always known about, and they'd rather go down the court route. So sometimes it's just about giving them the knowledge that the mediation can work, and then still give them the legal outcome at the end as well.
Yeah, it's really good to know. Now, let's look at a bit about how families are made up in the UK. So according to the British Social Attitude Survey, 46% of people still think cohabiting couples have the same legal rights as married couples do. And so is there any such thing as what's colloquially known as common law husband and wife?
No, unfortunately there isn't. It is a myth. It's something that is used quite often by people, but there's no such thing as a common law husband and wife. If your marriage isn't legally registered or recognised in the UK, then you wouldn't have the same rights afforded to married couples, and you would have to go under the cohabitation rights, so to speak.
Okay. So as we run Radio Ramadan, a lot of our listeners will only be married under the Islamic tradition of nikah. Is a nikah valid in this country?
So a nikah on its own is only valid if it's conducted by certain mosques which are registered to conduct the ceremony, and there aren't many mosques that are registered to do that. So for most part, the nikah on its own would not be recognised as a legally valid marriage in the UK, and they would go under the cohabitation rules. Yeah.
Okay. So how do you get your marriage recognised in English law?
So there's a few things for your marriage to be recognised under English law. It's got to meet certain requirements. Both parties should be 18 years old in order for them to marry. They both must have the capacity to marry. They must be doing it of their own free will. They must both be single, and they mustn't be closely related, and the marriage should be conducted by an authorised person to conduct those marriages.
And what are the consequences if the marriage isn't recognised in English law?
If the marriage isn't recognised, then they won't be afforded the remedies if the marriage breaks down that you would have if you were married legally in the UK. So they wouldn't be able to pursue an application under the relevant provisions to obtain financial relief. They wouldn't automatically have their home rights as you would if you were married. There obviously are provisions that they could use, but they're not as clear cut or as straightforward as the provisions you would have if your marriage was legally recognised in the UK.
Okay. So I suppose you said that there are provisions that they could use. I'm assuming that, well, I know from practice, but if you're under the nikah and you still have children under 16 and the marriage, the nikah breaks down, what sort of protections are you looking at?
So they can still make an application under Schedule 1 of the Children Act, which would allow them to make an application for similar relief as they would if they were married. It is a different process than the usual financial remedy process, but the court would still look at what it is that they require for the children up until they are a certain age.
Okay. And if there's no children at all?
Then you wouldn't have that option. You could go under a very long-winded route, but it wouldn't necessarily get them the remedy that they require for the breakdown of their marriage.
Okay. I know the family group resolution, and Sushma, you might have some interest in this. The family group resolution are sort of putting pressure on the government to reform cohabitation rules as well. I was just wondering from, a point of view, especially bringing in the mediation side of things as well if possible. And Harpreet, you can answer as well, but what you both think to the sort of reforms that, we're hoping to see.
Yeah, I think it's much needed. So if I think back in my days as a divorce lawyer, and we were dealing with those couples that came in, or certainly not wasn't couples, but the individuals that came into us who thought they had common law rights, it was heartbreaking, right? Because knowledge is power. It's the fact that there's lack of awareness. People thought, well, we've been in a cohabiting relationship for 25 years, and when they came to our offices and in fact they had no legal rights, it's devastating. So it's much needed because we're in an era where people are choosing not to marry. There are more cohabiting couples, so we've got to serve the new way of living, the new family arrangements. It's absolutely vital and important that there should be a law change from my point of view, but most importantly that awareness, isn't it? It's that education piece that's really, really important, especially obviously from my days back as a lawyer. I understand that sadly when the Muslim communities would come in through the doors, they often thought they were in a legally married relationship where they had the rights and responsibilities. And again, it's devastating to tell those that they don't have those rights and responsibilities. And as we just heard, it becomes a lot more complex. And in most cases, they don't get the justice that they deserve.
Yes.
Yeah, I agree. I think it would certainly bring in legal clarity for clients. It would align better with the way of living that there is now, like Sushma's just touched on. Lots of people aren't necessarily getting married, in that traditional way, I suppose. And it would align with that. It would take away that emotional stress and financial stress that parties have in that situation.
Yeah, great. And I suppose, I don't know if you could touch on the converse of that, because some people will go overseas to get married in Islamic countries, and then they come back and then they're questioning the validity of the marriage here. What's your comment?
Again, if it's conducted in the right way and it's registered, then it's legally recognised. But if it's not, then it's not legally recognised in the UK. And as Sushma's just said as well, there are a lot of Muslim clients who've done the nikah, or other clients from a similar background who've just had the religious ceremony. I actually had someone in my office earlier this week who had just the religious ceremony and has a child and wants to keep the whole of the property. Obviously I've had to advise her on that, and it isn't quite as straightforward. And she was quite surprised to hear the advice that I had for her. But certainly, it's the case when they get married abroad as well. As long as it's registered, it should be recognised in the UK. Otherwise, they will just have the same rights as cohabiting couples.
And when you say registered, you mean legally recognised in the country they were married in?
Yes, that's correct.
Yeah. Okay. In 2022, the government brought in what we know as the no-fault divorce. What does that mean?
So that means that both parties can now divorce without apportioning blame to the other person. There's only one thing that they need to prove is that the marriage has irretrievably broken down. Prior to that, they would have to prove one of the grounds, such as unreasonable behaviour or adultery, 2-year separation, and those sorts of things. Whereas there's none of that now, and it is a step forward to that amicable divorce that we're trying to achieve, because we're no longer apportioning blame, and you simply need to let the court know that the marriage is broken down.
I mean, it's quite good to see that the UK has caught up with other countries like France and Islamic traditions where we're all adults. If the marriage is broken down, the marriage is broken down.
And it wasn't serving anybody, right? No. Having a fault-based system, it only just entrenched and gave more trauma and heartache to those that are facing divorce and separation. So, from my point of view, I've been a member of Resolution. You mentioned Resolution, Gina, which of course is a body of predominantly specialist family lawyers, as well as other professionals, mediators, financial planners, therapists who are part of Resolution. I've been a member for the past 30 years, and we were lobbying Parliament for years. It was such a huge outcome to have that made legal, and I'm sure it's going to be helping thousands of couples moving forwards to put the blame down. Let's focus on the task at hand. What's more important to us is hopefully trying to get an amicable resolution to all their issues regarding children and finance.
And I think especially when you've got children involved,
it certainly doesn't help to apportion that blame. And we've seen as well, it doesn't further the case for the finances to apportion that blame in divorce proceedings. I mean, I don't know about you, but I do still often get clients coming in sometimes saying that they want to blame or cite the other person's behaviour and conduct, but there's nowhere to cite it anymore. It's just not a requirement.
Exactly. And it takes trying to explain to clients that the conduct's got to be pretty severe, and it's pretty much litigation conduct for it to have an effect on the outcome of the finance procedure. It's quite difficult.
And those clients who want to cite and set out reasons, of course, it's because their brain's hijacked. They're emotionally not in control, and they're not thinking clearly. They want revenge. They want to have their day in court. But what we need to try and do is remind clients, yes, they do need space to vent, to process, but not within the legal setting. We need to try and encourage and promote, go to counselling, go to therapy, absolutely have that opportunity to process and feel, because that's got to happen. For them then to come to the table with you guys, to have the sensible head on their shoulders to make the right decisions for them and their families. So, that's really important for all of us to recognise that, all of us professionals serving the community that going through divorce and separation, we need to know when to signpost and give that knowledge and information to clients who hopefully will take it on board. I mean, but we all know we can take a horse to a water, but it doesn't always drink it.
Indeed. And sometimes as family lawyers, you're therapist, coach and lawyer all rolled up in one, aren't you? Social worker.
And that's the thing, is that we need to know our boundaries. I think that puts a lot of pressure, doesn't it? Especially when I remember my heydays as a younger lawyer, I thought I had to be everything to the client. But as you get a little bit older and wiser, you begin to realise, actually, no, I'm skilled and trained to be a lawyer. I don't have the skill sets for the things. Obviously now I do, because I've evolved into a new professional being. But if we all knew our boundaries and we knew where to, I guess, cross-refer and work collaboratively to serve our clients, and that will be, better for everybody.
Indeed. And then on the other side of things, at the beginning of relationships, we have the prenups. How much weight do prenups actually have in the UK?
So a prenup is a contract that parties can enter into prior to marriage to set out the ownership of their assets in the event that the relationship broke down. It isn't the most romantic thing in the world, is what clients tend to tell me, and they don't always want to do it. But there are obviously a bunch of clients that do it. In order for it to carry it, so it's not automatic, it's not legally binding automatically. it can be upheld in court if certain requirements are met, and those requirements need to be that it's done voluntarily. There's been no duress from one person, from one of the parties to the other parties. Both parties have provided full financial disclosure to the other party. Both parties have had the opportunity to seek independent legal advice, and that they understand the implications of what they are doing. The agreement's got to be fair, so it can't be that one person's getting everything. It does need to be fair, and it needs to be signed well in advance of the ceremony taking place. So, not just the morning of the ceremony.
You don't want the pressure.
No, that's it. But ultimately, it's up to, if all of those requirements are followed, it will certainly be something that can be presented in court and hopefully upheld. But ultimately, it's up to the judge whether or not he believes or she believes that prenup is valid and should be upheld.
I mean, I would argue that prenups are romantic because you enter into them at the beginning when everything's lovely. The sun's out, the flowers are dancing, the birds are chirping. You're in love,
Yeah.
So
then it's the insurance policy, isn't it?
Exactly.
It's like we're hoping we don't ever have to cash in on this insurance policy. When our emotions are not heightened, we can think sensibly. And I think younger couples, they're probably more amenable to it. They're more savvy. They're beginning to look at things very differently. I think it's the older generation. We're wired in a different way, and we need to uninstall stories, beliefs that don't serve us anymore, and rewire ourselves in a different way.
Certainly. I mean, it certainly makes sense to do it at the start than to do it when, like you say, emotions are high and you can't think straight, and people are less likely to have an agreement that they would have had at the outset.
Yes.
So they are certainly advisable as long as the steps are followed.
Yeah. I mean, so Harpreet, even with all the eligibility requirements in place before the prenup is signed, is there ever a time when a judge would still override it?
There is a time if all of the elements are in place, I would think that it would stay in place. I think the only time that the judge would override it is if they felt that it wasn't fair, or that it just wasn't done properly. Or one of the big ones is where both parties haven't had independent legal advice.
I suppose it being fair, you could say fair in the circumstances as well, because sometimes circumstances change so much. That you've got to meet need, haven't you?
Exactly.
Like that.
Because what they might have decided at the very outset may not actually reflect their current family situation. So in that sense, it can be overridden by the judge.
Yeah. Maybe as your family circumstances change, maybe go for a review.
Yes.
And I suppose you could use mediation services for that sort of thing before sitting down with solicitors.
Yeah, certainly advised to go for a review of it, because as you say, circumstances change, and whilst you've got the prenup, which is done on the outset, you can also have a postnup, which is done after, and often is done. I'm not sure if you've had much experience of it, but I found it's often done when parties have perhaps come back from a breakup or a similar situation.
We've just had a question come in. Salams, I'm born here. I married my Indian husband 27 years ago. He's British now. We were married both nikah and civil marriage there. I go by his surname and always put myself down as I was married on all formal documents. Is my Indian marriage legally valid here? What would you say?
I'd say yes, it is, because they've had a civil marriage over there. So you'd be recognised as legally married in the UK.
Okay. So if he were to pass away before me, would I have legal rights as his widow to his finances, or him to mine if I go first?
That would depend, firstly, if there was a will. If you left a will, or if you leave a will, then it would go in accordance with your will. If you die without leaving a will, you are recognised as his wife. So under the rules of intestacy, you would inherit. But I can't advise too much on that aspect.
Yeah, we can only advise on the face of what we see.
Yes. Yeah.
Thank you. Shades. So, Harpreet, are you able to tell us about Jade Ward and her sad case, which led to the Victims and Prisoners Act, and what does that mean?
Yeah. So the case of Jade Ward is a sad one. She was murdered by her estranged husband, who was then convicted to life imprisonment. Despite his conviction, he of course held his parental responsibility in respect to the children. They had 4 children together, so he was still able to make life-changing decisions for his children from prison. This highlighted a gap in that legal framework, and it was Jade's family that campaigned for a change to protect children from further trauma. And in response, the UK government amended the Victims and Prisoners Act to include Jade's Law. So any parent that's convicted of murdering their partner or ex-partner would have their parental responsibility surrendered. And that would be automatic at that point. It also protects children from psychological harm that takes place, which, that was quite a big change to be brought in.
Can you tell us a bit more what parental responsibility means and how does one acquire it?
Yes, so parental responsibility is all the rights and responsibilities that a parent has in relation to their child. A mother would require it automatically if she gave birth to the child. The father would acquire it if the parties were legally married. He would acquire it automatically if he was married to the mother at the time of the time of the child being born. If the parties were unmarried or married but not legally recognised, as we've touched upon, then the father would only acquire the parental responsibility if he was named on the birth certificate. He can acquire it afterwards if his name isn't on the birth certificate. At that point, if there was an issue about DNA, then that would have to be determined before it can be changed. But certainly it can be put on retrospectively if needs be.
Okay. I was speaking to Naila last week on the Criminal Law Show, and there was a big change in law in knife crime because of Ronan's law, which was another mother lobbying on behalf of her deceased son. Then we had, a few years ago, we had Claire's law, which was again lobbying due to domestic violence. And now, we're looking at Jade's law as well. And it's starting to feel like the big changes that we need are being done by the families. It's been lobbied by the families.
Yeah, absolutely. I was just thinking that it's driven by people in pain. And what you do is you change pain into purpose, because you've had a real trauma, heartbreaking situation. What do these parents do? They don't want others to go through this, and thankfully they're then channeling it in a channeling their feelings in a positive way, right? To try and make change for the people. But you're right. There's so much of this coming through the news. What was I watching? Adolescents. So it looks like there should be a sea change or shift on the back of what people are doing, not within necessarily government or through the appropriate channels, but it's through dramas or through actual life experiences.
Indeed. I suppose that's true democracy.
That's exactly.
The
people rising to the top. Absolutely, it should be top down.
Indeed. There's another change in family law, where family law has always been conducted in private. The hearings, has always been conducted in private. But there seems to be a big shift into having more transparency in family law, especially because some of the judges' decisions in children matters have been criticised, and people always say, well, it's done behind closed door. We never know how a judge gets to that point. What can you tell us about the transparency rules?
So there's there is a shift towards increased transparency in family proceedings. So as of January this year, there has been journalists and legal bloggers can come into the courtroom, which was never allowed previously because family proceedings are always seen as private proceedings, and that is there for there to be greater transparency, so the judicial decisions can be heard. It encourages fairness and consistency, and the openness is obviously there to ensure that the system is actually accountable for the decisions they're making. Of course, it's going to lead to criticism, especially for the parties involved. It takes away the privacy element. It isn't something necessarily that some families would want, but certainly there's a greater shift towards that now.
What do you think?
So from my perspective, I guess the point is, if they're looking for confidentiality, they need to be looking at non-court dispute resolution options, right? So that's what's important to understand, is that if you've got family affairs that you want to sort out and it's not got extenuating circumstances, that it's got to be within the court forum, then look at the creative ways that you can try and resolve your disputes, because most of the non-court dispute resolution options, in fact all of them, will be undertaken on a confidential basis, right? So that's something that your audience will want to understand and know, that if you want to keep, if I call it the dirty laundry, away from public eyes, then the best place is to try and deal with it within one of the non-court dispute resolution forums. And I'm not saying that's mediation, but from my litigation days as a lawyer, quite often we'd have roundtable meetings, we'd keep things private, and we'd have the clients around the table with the lawyers, and we could then quite quickly reach resolution. But it takes two willing participants. So the key thing to understand is, quite often one may be willing to work in a non-confrontational way, in a collaborative way, but if the other party isn't quite there yet, so in the emotional journey of the bereavement, of the separation, if they're in anger mode or head in the sand, they're not going to be wanting to collaborate, and that's when we often end up in court. And it's all to do with understanding where are these people emotionally. Quite often, if we give one the space and grace to catch up with the other one, then there'll be more amicable and holistic divorces, from my point of view.
And I think it does also depend on where they tend to get their advice from, and as long as also all lawyers are on the same sort of page as well. Ultimately, there are cases that cannot be resolved in mediation, or they need to be settled in court, but certainly with a view to having those cases settled, rather than them being dragged on for longer than they need to be dragged on.
Sushma, roundtable collaborations seem to be making a comeback. I mean, I've never done one in my career, because I think they were out of the window by the time I started training, sort of thing. But they seem to be making a comeback. What do you think are the advantages of doing it that way? And are there any risks, I suppose, as well?
Well, in terms of roundtable meetings, of course, collaborative is a very different approach. So collaborative approach is where you've got collaborative trained lawyers, and those trained lawyers who have undertaken the collaborative training would get their clients to sign up to agreements to say, we're going to follow the collaborative approach. And the drawback in that is they're saying that if within the the roundtable meetings that we set up as collaborative lawyers and working together, you don't manage to reach resolutions, you can't then use this in litigation. So the drawback for clients when they're using the collaborative approach, which is through trained collaborative lawyers, is that they won't be able to use the same legal teams that have to go elsewhere, because there would have been lots of confidences that would have been shared. Because what we're trying to do is we're trying to get people together around a table and be transparent, put your cards on your table. What's going to feel comfortable? What can you live with, right? Now, going back to the old way that I used to deal with it, because I wasn't a collaborative trained lawyer, I was just like you both, a trained lawyer. But we did used to, back in the days, have these roundtable meetings. So it's how I can describe to your audience is, if we watched any of the American programs where you see they've usually got their clients around a table, right? And the idea there is to try and deal with things hopefully in a day or a couple of days. You have built-in breaks, you have an agenda, you have meetings together as four, or if there's more of you in that room, but you can have breakout rooms. So the advantage is that you can try and reach resolutions, and you agree the agenda items, and you can try and fast track everything. If you do reach terms, the lawyers would then have heads of agreements, and they could start preparing the financial consent order documents, right? There's no real drawback in those in the roundtable meetings, because what you're going to both be saying is that any discussion here is without prejudice. So you, as legal lawyers, will know that none of you can then rely on, well, he or she said this in a roundtable meeting, so we can then hold them to ransom at court. So, there would have been that caveat in place. We're always doing roundtable meetings on a without prejudice basis, just like you do, when you're in FDRs or what have you. But there should be a comeback, because people don't. Court is toxic. The court's on its knees. There's a huge backlog, and we need to be creative. How can we keep our clients out of court? And for the clients who feel vulnerable, they don't want to be in a traditional mediation setting where they're with me and they're having to front face the mediator and broker their own deals, because they haven't got the confidence, or there's unequal bargaining powers. So the advantage is perhaps doing it in a different way, like we're suggesting. I mean, there's new models of mediation. You have mediation hybrid mediation, where lawyers are actually engaged. I've not trained for that, but there are so many different models, as I said, appearing and popping up to try and meet the bespoke needs of clients, right? Ultimately, It's what's going to serve them, and again, it depends on their financial capacity, because there's obviously additional costs associated with various things.
Yeah, but going to court is still extremely expensive anyway.
Oh my God, absolutely.
Yeah.
And coming back to like arbitration, so people think, well, arbitration, why do I want to hire a private judge? Well, it's going to be quicker. It's less stressful. You're not actually having to comply with all these complex rules that we have to. I don't have to anymore, but you guys still have to when you're in court. And so, you might have to pay and share the cost of a private judge, but you're going to get things sorted out so much quicker, and it's less stress emotionally, you know. So that you're absolutely right. Whilst, you know, certain non-court may seem like, well, we're going to spend money, but it's money well spent.
Indeed.
And it saves on the thousands pounds in fully litigated case, doesn't it? And the time frame, I mean, I don't know what the delays are like at the moment.
They're quite extreme.
It's extreme.
I mean, I think you're preparing clients for at least a year from start to finish. I mean, I issued a case earlier this week, and the first hearing is towards the end of May. So that's already you know, a good couple of months before anything is going to be resolved or even looked at.
I mean, we issued a case in September but it was property, so it's outside the usual marriage, but it's under what we call talata. It took 5 months for the court to issue proceedings.
And this is the thing, people need to be clued up to recognise what are the creative ways, because do we want to be in litigation for a minimum of 12 months, if not more? And then I understand the judges, there's a huge issue about judges not being available, and then you could be set up for a case, and then the last minute you're taken out.
And then you've got the added cost element there.
And actually, I don't think court is as predictable as it used to be either. When you go and you kind of know what order you're going to come out with, but the judges are trying to resolve things so quickly that sometimes they're pressing very early at a time when you wouldn't expect them to be. You know, so you could end up with a final order at a case management hearing.
I mean, I had a case yesterday and ended up with a final order on an FDA hearing, and I'd only just taken it on from another firm of solicitors, so it was a good outcome for both parties.
I was going to say that seems like a great outcome, as long as parties haven't felt coerced into reaching an agreement, being bullied by a judge or their lawyers. That's the main thing.
They were very happy with the outcome, but it's also, you know, had that case gone on to the FDR hearing and then final hearing, they'd still be here probably later this year. Whereas matters are now concluded, and they can start to move on with the other aspects of their life and actually deal with the emotional side of it, which they think they're dealing with when they're with us, but it's impossible because there's no closure, and it's only when they've got that closure they can start to move on with that final
Can
order.
I just take you up on that, Harpreet? I don't think it's impossible. I think the point is we all need to be encouraging our clients along the legal journey to deal with the emotional journey. So for me, really important, my awakening was stepping into our client's shoes. So I'm a divorcee. That was a huge awakening, right? I realised I'm flawed by this experience, and I have got all the knowledge as a lawyer and as a mediator. But at that point, I realised, you know what, our clients are going through trauma, and what we need to do is, whilst we cannot be there everything, along every time, the moment that we get, we've got to encourage them. There are so many resources out there, and they don't have to necessarily pay for a counsellor, therapist, or a coach. There are lots of free resources, communities. It's like leaning in with whatever is available, right? And actually, I always say to people, please try and deal with your divorce and separation in a holistic manner, mind, body, spirit, and soul from the start. Don't just deal with it legal, because if you're dealing with it just as a legal aspect, you're right, you're in survival. And that's not helpful to anybody. It's like you're going to collapse. You're going to have a breakdown at the end of this legal journey. But if at the same time you're recognizing, I need to give myself space and grace in the other party because we're going through trauma, whoever's right or wrong, our children are going through trauma. Everyone's processing at different stages. How can we take a step back and look at things a little bit differently? And that means hopefully taking help and support from whatever resources are there, alongside from professionals like yourselves and other professionals that are going to help them. So I would say it can be undertaken, but again, knowledge is power. It's people knowing that it's not just one path. I don't have to just stay on one path. It's fluid, it's flexible. You know, I can kind of address everything. What's most important right now? And for me, I'd say the first thing they need to address is the emotional side. If they're in survival, they're not giving you the right instructions. They're not making the right decisions.
Making the right decisions. Well, they can't stick to a decision.
No.
Which is gets quite difficult.
It does. Yeah, it can get difficult because they can change that decision just overnight because they're not in the right emotional state.
Yeah.
Yeah.
And it's important then for you guys to sort of recognise, well, you can't be the counsellor or therapist because you don't have the skill set to do that. But that's when you're signposting. Counselling and therapy is talking. It's about processing the past.
Yeah.
Coaching is, well, they've undertaken that, and now they're stuck. Now they need to, change their ways, moving forward, right? So I guess that's where, like me or other coaches come in, and people are often saying, well, how do you complement? How do we work together? Well, that's the point. Is that you guys know, well, this is what I do. I give legal advice, but if you're needing another, sort of way forward, lean in with other professionals and see what it is that you need. It may just be that it is the talking therapy and counselling an issue that they need, or it may be that they do need to work with a coach alongside lawyers to make sure that they come to you in the right frame of mind to then make those right decisions, as opposed to being hijacked by emotions.
Indeed. Yeah. Great.
No, I do agree with that. I think it is about all the professionals working together as well and kind of referring on where needs be, because you're absolutely right. Sometimes we as lawyers do not necessarily feel, but we do hear all sides of it. So, but there is only one role really that we can fulfill unless we've got the skill set for the other roles, which we obviously, don't all have. And then it's about getting them that help so they can think clear with their instructions. But certainly from that first meeting they have, they're often, the emotions are heightened, aren't they? And the instructions aren't always very clear. But certainly once they start to process those emotions, then as the case progresses as well, and hopefully as they seek that other help as well.
Indeed. Just to finish, I came across a new bill yesterday, which I'm quite pleased about. It is an employment law bill, but it actually affects some of the clients that we deal with, because it's helping people that are going through domestic abuse. And it's called the Domestic Abuse Safe Leave Bill. And what the bill is trying to do is introduce a new right that gives employees 10 days paid leave if they're experiencing domestic abuse to deal with the issues relating to abuse. Issues may include things like health, housing needs, finding a place of safety, childcare, attending court and police interviews, and attending counselling and so forth. And I thought that was such a big step forward, because a lot of times when people go through this, they have to take unpaid leave or take the holiday or something like that. So they're very limited. And it also puts an emphasis on the employers to make sure that they're having this time out so they can safeguard themselves. Because a lot of times employees don't really understand what's going on. They don't always understand what domestic abuse is. And they sort of expect you to sort of get on with it and, meet the business needs, really.
And especially when there aren't any physical signs necessarily of that, it's hard for that understanding to come. And that's certainly a step in the right direction for employers to recognise that and give that leave as well, so those parties can be safeguarded.
It takes the pressure of the person who's going through this trauma to understand that they're going to have these rights to take some time out. This is what we're talking about. If they do get that paid time out, we're going to have less dysfunctional families, because people hopefully go and take the help that they need to resolve the emotional side of the divorce and separation trauma. And just touching on what Harpreet said, the number of times when I'm doing safeguarding and screening and I ask the questions about domestic abuse, and obviously it's a wide definition, the first thing those that have not endured physical violence would say, he or she hasn't hit me. I'm not. But when they describe what the behaviours that they've experienced, they need help to level awareness to understand that they are going through domestic abuse. So then I'm signposting out to, you've heard of the Freedom Programme, and there's various programmes that help victims of domestic abuse. And it's empowering them, isn't it, to not be in victimhood, but to step out and not, attract the same partners. But really important.
And that is a big thing, attracting the same partners, because a lot of time people will,
pattern.
They're going through all the legal proceedings, they're separated, and then they start a new relationship during legal proceedings, but they've chosen exactly the same person again, just with a different name and a different look. And
that goes down to deep-rooted childhood trauma. And that's the point about saying the therapy, the inner work, the healing, it's so necessary, but it's painful. People don't want to feel that pain and go through that threshold. But if they do, they won't. They'll break that pattern, that behaviour, and they'll start to make changes in their life that's going to serve them and their children if they've got any.
Exactly.
Yeah, I think there definitely needs to be a change, and I do think a lot of it is a cultural change as well.
Yeah.
Going back to the point of, he didn't hit me or she didn't hit me.
Yeah.
I think a lot of it is being conditioned in a certain way, and it's that thought process that also needs to change to recognise that for people or clients to recognise that domestic abuse isn't physical, it's a variety of things.
Ladies, thank you so much for all your insights and your expertise. I hope that the things that we've discussed today will actually help our listeners, but obviously they can also get in touch with us if they do need that extra advice. Thank you.
Thank you.
Thank you.